In 1972, delegates from across the globe gathered in Stockholm to formally recognize the urgent need for environmental protection. The Indian government moved quickly following the conference. Throughout the 1970s and 80s, the country drafted a robust framework of environmental laws, including the Water Act, the Air Act, and the Comprehensive Environment Protection Act. But despite these strict rules on paper, enforcement lagged behind. As India's economy aggressively expanded, industrial smog, untreated wastewater, and unchecked ecological degradation accelerated rapidly across the entire country. Writing a law is relatively straightforward. Actually enforcing it against entrenched industrial interests requires a dedicated mechanism, something the original legislation lacked. In 1995, the government attempted to build that mechanism by proposing a National Environmental Tribunal. However, it never became fully functional.
Without a specialized body to hear these cases, citizens and activists took their grievances directly to the high courts and the Supreme Court. Thousands of complex environmental disputes flooded the dockets, choking an already backlogged legal system. Traditional legal systems rely on linear, precedent-based arguments. Ecological sciences deal with compounding, multivariable data. A standard judge is highly trained in statutory interpretation, not in hydrology, atmospheric chemistry, or biodiversity tracking. Because of this, traditional civil procedures often stretch environmental cases out for years, or even decades. While legal teams debate motions and file appeals in the courtroom, active and irreversible ecological damage continues to spread in the real world. The traditional court system simply moves too slowly to halt ecological collapse. A completely different kind of adjudicator was required. In 2010, the Indian Parliament passed the National Green Tribunal Act. This established the NGT, making India the first developing nation to create a specialized environmental court. To ensure citizens across a massive country could actually access the court, the NGT was decentralized. A principal bench in New Delhi is supported by 4 regional zones in Bhopal, Pune, Kolkata, and Chennai. Crucially, the bench pairs Supreme Court and High Court judges directly with expert members, scientists and engineers with decades of field experience. To insulate these members from political pressure or corporate influence, they are appointed to strict 5-year terms and are completely barred from reappointment. This structure guarantees that environmental science isn't treated as mere advisory testimony. It is physically embedded into binding judicial authority. The NGT holds sweeping civil jurisdiction over 7 major environmental laws, covering air pollution, water protection, and biological diversity. It intentionally bypasses the rigid Code of Civil Procedure from 1908. Instead, the tribunal operates under a clear statutory mandate: dispose of applications and appeals within 6 months of filing. This conceptual logic flowchart shows the operating framework of the NGT. If an entity causes ecological damage, financial liability routes directly back to them. This is the polluter pays principle. The tribunal also utilizes the precautionary principle, meaning it can halt projects based on a reasonable suspicion of environmental harm, rather than waiting for absolute scientific consensus after the damage is done. By prioritizing speed and natural justice over procedural technicalities, the tribunal shifts the burden of proof onto the corporations and agencies accused of causing harm. The NGT backs its rulings with severe enforcement mechanisms. It can levy fines up to 10 crore rupees, roughly $1.2 million, and sentence violators to up to 3 years in prison. When devastating floods struck Uttarakhand in 2013, the tribunal applied the polluter pays principle directly, ordering hydropower companies to financially compensate petitioners for damage exacerbated by their construction projects. The tribunal has also demonstrated a willingness to halt massive economic ventures, notably suspending the POSCO steel project to protect local forests and the communities relying on them. These aggressive rulings have generated intense institutional friction. Various high courts have frequently challenged the NGT's authority, arguing that as constitutional bodies, their power supersedes that of a statutory tribunal. The NGT also operates with significant jurisdictional limits. It cannot rule on cases under the Wildlife Protection Act
or the Forest Rights Act, leaving large gaps in the legal protection of indigenous communities and vulnerable ecosystems. Even with these legal blind spots, chronic underfunding, and pushback from established institutions, the NGT serves as the primary arena where a rapidly developing nation negotiates the tension between its economic momentum and its ecological survival.